All right, the title of this panel is Battle of the Branches, and in reading it, you might be forgiven for asking a battle. What battle? So this year, we have these seminars we teach in Chicago, typically at our houses at night, for the whole year with a small group of students. And mine this year was just to sit down with the students for the year and read the Federalist Papers in order, which we just completed the other night. And not because there's some dispositive font of constitutional meaning, but just to really kind of see what the arguments look like in the context of these essays and the order in which they were many times printed in the New York newspapers. One impression we all got, and I think this is not a new insight, is that Hamilton had amazing energy and a very forceful, argumentative style. He would be one of the great bloggers of our time if he were around today. But that Madison seems to be the more scholarly of the group. He's the one who seems to literally agonize over the words in the way many of us do when we're doing our own writing. And it doesn't mean, of course, that Madison gets everything right, or certainly that he can see the future, even the near future, that the country would have after the adoption of the Constitution. So this was briefly mentioned in at the end of the last panel, but one of the most famous Federalist Papers is, of course, 51. It's authored by Madison. And he makes two interesting claims. One, I think, probably will persuade people, which he makes clear he does not think all of these, what he calls parchment barriers put into the text, will be the protection we need from authoritarianism over weaning concentrations of power. He says if that's all you had, it wouldn't do it. So a realist in that sense. But then he makes the famous claim, and I'll just read it to you because I think it relates to all the papers for this panel, which is he claims that the structure that the founders have come up with will provide enough security against too much concentration. He says the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. We can all, as we listen to the presentations, think about to what extent that is held up or not held up. A lot of things have happened since he wrote that particular intervention. All of the panelists have written fully developed papers relating to separation of powers. We're going to hear about them. All of them, I think, talk about problems with our current separation of powers system. Those include restrictions on the ability of courts to adjudicate disputes between the branches, abuses of the pardon power, an erosion in Congress's core power over appropriations, and the idea of exclusive presidential powers that are ostensibly unregulable by Congress. So we're going to hear about each of those papers. I've asked them to spend about 10 minutes each describing for us what those papers are doing. I then want to have some time where they can respond to each other and make comments. And then I definitely want to make sure this is such a topic that everybody has an interest in, that there'll be some time for questions at the end. So we'll just start and go, I think, in alphabetical order. And so the four panelists are Payvand Ahdout from the University of Virginia Law School. She's going to talk about interbranch litigation. Lee Kovarsky from University of Texas, talk about patronage pardons. Zach Price from the University of California, San Francisco, talk about Congress's power of the purse. And Shalev Roisman, University of Arizona, will talk about the exclusive powers of the presidency. We'll start with Payvand.
Hi, I'm so glad to be here. And I'm so glad to be among these panelists because throughout the semester, I've taken all of these papers, downloaded them off of SSRN, and put them in a queue of you got to get to reading these. And so I finally got a chance to force myself to read the papers I wanted to read in preparation for this panel. So the title of this panel is Battle of the Branches, which is really how I've thought about my agenda and research over time, and in particular with one aspect of that. And that's how does litigating the Battle of the Branches, the separation of powers, inform the content of those powers? Because we know that adjudication has bounds, and we know that those bounds affect the ultimate dispositions that are reached in the cases. And so I've been preoccupied with this idea about litigating separation of powers and what that means for the ultimate conclusion about what we think a power includes or excludes. So I have sat in some uncertainty in all of my work thus far about what happens when one branch sues another inside of the judiciary. I've excluded it from most of my work because I've thought these are really hard and they've got so many dynamics inside of them that I need to spend some time and sit in it. And so what I did is to take every single case where one branch sued another, whether it was in a district court, whether it made it to the Court of Appeals, or in the rare instances, it made it to the Supreme Court. And I sat in the cases for a year. And I thought really deeply about them and took them on their own terms. And I tried to come up with the coherent principles that underlie what's going on in these cases as a set. It's not an easy exercise to do when most of the cases are occurring in lower courts with different judges over a long period of time. Sometimes it's district court judges and sometimes it's Court of Appeals judges. Very, very rarely a question like this gets all the way to the Supreme Court. And I had to make some choices. So one of the choices I made was to exclude, for example, mandamus cases. Why? So they appear to be, right, like the district court will be in the name, but we've got a mechanism for thinking about those cases that I think is exogenous to this particular sort of thing. And I've excluded intervention when another branch intervenes in a case, which Congress has sometimes done, because I've written about that a little bit, and it seems to be categorically different than initiating a lawsuit against another branch of government. And as I was sitting in these cases, we got a new president who also started to threaten and actually bring litigation against other branches that were different from the cases that I had assembled. So President Trump's administration ended up suing the District of Maryland, and I thought, this is new and good for business. And he threatened to sue the Senate over some of their internal policies. And I thought, if I can take these cases, which are mostly about Congress suing the president, and think about the dynamics within them, how can I relate them to each other to make and tell us a story that is useful as scholars, useful as observers, maybe useful to judges, maybe useful to litigants about what the principles are for interbranch litigation. And I think there's a lot of way to sort out the material, and that's sort of what we see in the paper that I've written. One is chronologically, where did this come from? And what we see, or what I found, is this all starts in the Nixon administration, and I don't have a reason for why it starts in the Nixon administration. Most of the cases are about Vietnam and Cambodia, but we had other sorts of controversial wars before then, like Korea, and that's not a place where we see litigation. So I think it might be congressmen were trying to find some way to press back on these extraordinary uses of power, and they were seeing courts at the same time being receptive to different kinds of claims and step out of a dispute resolution model as such. And so maybe that's what's going on. We could divide this material up by powers. Foreign affairs powers versus specific powers that Congress has domestically that it's challenging. And it turns out that when you divide it in that way, courts are more reluctant to hear cases and get to the merits on foreign affairs issues, and more willing to grapple with the domestic affairs space, specifically with information disputes, subpoena power in particular. Courts have gotten much farther along in the litigation, but they're not sort of inclined, I've found, to find that Congress has an interest once a law has actually been passed. If it's been passed by both chambers and signed into law, courts are not inclined to hear a case that becomes more of a generalized grievance. They've said, sort of across the board, with very rare exception, that in those instances, Congress is no differently situated than an ordinary citizen. Then we got to the part that I really love, which is the doctrinal part. What are courts actually doing here? And it turns out most of the discussion is about justiciability roles. And I'll say here is the part where I put on my Fed courts hat the most. I had the most creative license to sort of read the cases and tell you not what they think they're doing, not what they say they're doing, but what they're actually doing. And I think that in these cases, there are two core principles of justiciability that come up often. And the first one is the question of standing, which comes up in many kinds of disputes. But one of the main principles that courts have created, articulated here, is that for Congress to bring litigation, it needs to have an institutional interest, and it has to be an institutionally significant plaintiff that brings it. So what does that mean for our purposes? It means we need a majority of a House or a majority of a committee that has jurisdiction over the claim that they're making. And this particular rule had, for me, one of the most striking effects outside of Congress, which I'll talk about in a second. The second thing that courts developed is what I call the political ripeness doctrine. And by this, I mean courts want whether it's the executive or Congress, to go and exercise their constitutional duties and powers outside of court and either exhaust them or show that they're not working before they get to court. Sometimes they do this in the frame of the political question doctrine. Sometimes they call it standing. Sometimes they just call it abstention. But really what they're saying is it's not ripe for adjudication now. And what I found was most striking is I had gone in thinking political question doctrine will do real work here. And I don't think it's the political question doctrine that we learn about in constitutional law that's doing any work here. So courts will use the words political question doctrine, which I know you have found in your work, Kurt, but they don't mean political question doctrine. They mean this question is political. And so I talk about in the paper why the political question doctrine is not useful. And then I found this vestige of a thing that existed in the DC Circuit for a time, where courts would say, the parties have standing, we can hear this claim, it's not a political question, but nonetheless, we are going to use our equitable discretion not to issue a remedy. And I think that's kind of weird to say we're going to use our equitable powers to not give a remedy in this situation. Sam, nod with me, am I right? Is that weird? Maybe it's not so weird. Okay, we'll talk about that later. That's why we're here. Okay, weird. So he says weird in a good way. I say weird in a bad way, but we'll have some fun later. But for me, the main thing about this paper is what is the effect of all of these justiciability rules? And I think that when courts talk about their powers in the context of interbranch litigation, we should not be surprised that by articulating the bounds of the judicial power, they are saying something and shaping the other powers that are in the room. And that's different than when there are private litigants in the room, I think. And so for me, the core interesting insight here is how a court says no shapes how the branches exercise their power outside of court. So for example, in saying that we need an institutionally significant plaintiff in Congress to bring litigation and that a single member can't do it, what has in effect happened is that the Speaker of the House has considerable power and the political majority has considerable power in shaping what actually gets to court. So this litigation has become hyper-partisan, which is why we don't see it today with unified government, but why we might expect it on divided government. Second, in the ripeness doctrine that they've articulated, courts have said, go back and use your power of negotiation between the executive branch and Congress. And what that does is instantiate the structural disadvantage that Congress has in negotiations with the president generally, because the court thinks there's more room for negotiation, but Congress is coming to court because the status quo does not benefit them. They are, by definition, right? Like they have a harm that they're trying to respond to. And so if there is a limited time window in which to fix things, the fact that courts say, go back and use your powers of negotiation to do more before you come here is going to instantiate some of this disequilibrium that we see between Congress and the president. So I'm going to stop there and turn over to Lee so that he can tell us about his wonderful paper.
And I'm going to go up here just, I don't know. It's how I'm used to looking at my notes, and I would feel weird doing it the other way. Anyways, thank you for having me. I feel like 48 years of Jewish upbringing have led me to this moment where I stand here and say I'm Lee Kovarsky and I'm a pessimist, and I feel guilty about it. Anyways, broadly speaking, I'm a scholar of criminal law and procedure, death penalty and mercy. The paper I presented today is called Patronage, Pardons. It grew out of my work on mercy power, but it's kind of got a twist. I'm not approaching this question the way criminal law scholars would, or I would have in past lives, as a vehicle for mercy or as some kind of corrective for unjust punishment. I'm approaching the pardon power as an instrument of regime control and loyalism. A quick word on terminology. Patronage pardoning is a term I invented. It's where a presidential patron incentivizes loyalism by using clemency power to dispense immunity from criminal law. Patronage pardoning differs from ordinary clemency practices in its public communicative function. What we are seeing isn't just a difference in scale now, it is publicity, it is performance. Patronage pardons signal impunity for regime allies. They power something like an uptown loyalty for a protection racket. I'll slice my talk up this way. I'll say a little bit about the history of pardon practice. I'll explain why patronage pardoning is weird bad. It's sort of a new and exquisite threat to the order, and I'll talk about some potential correctives. So start off with history. I'm not going to recap all of it, but I'll emphasize two big propositions. First, the framers knew this risk and they assumed it anyways. Second, what's happening now is genuinely new in kind, in degree, in invisibility. And on the first point, I'll be honest, the history went against my priors. I would have loved it if I found evidence that the framers just didn't think about this problem or that they assumed the pardon power just wouldn't operate in this way. That would make a cleaner paper, more strident content. But that's not what the record shows. The key English episode involved Lord Danby, dispatched in secret by King Charles II to dangle English military neutrality before King Louis in exchange for France paying England money. Well, Parliament impeached Danby. Charles pardoned him. There was a constitutional crisis. Danby spent 5 years in the Tower of London. The lasting lesson wasn't that pardon power should be constrained. It was that impeachment and removal of subordinates were sufficient checks on a king who used pardons to induce crime against English interest. That assumption made its way into American constitutional design. But the American pardon power sits in a very different governance ecosystem. And the idea was that the president was even more accountable than the English king for pardon malfeasance. At the founding, Edmund Randolph raised my concern explicitly. James Wilson's answer was that impeachment took care of it. Hamilton said the same thing in Federalist numbers 69 and 74. James Iredell went even further and he says that nobody would risk, quote, the damnation of his fame to all future ages. And the framers made the pardon power nearly absolute with eyes open to the risk. I also don't think people can dispute the second point, that patronage pardoning is actually happening. The signal pardons, pun elocuted but not intended, are well known. January 6th, Scooter Libby, Paul Manafort, Michael Flynn, and a cascade of second-term clemency backed by the cri de coeur of the Office of Pardon Attorney, no MAGA left behind. What really captures the change, though, is a cultural shift inside the administration. You have Corey Lewandowski walking the halls of DHF telling staff he can do whatever the F he wants because he knows he's getting a pardon. You have a number of high-level Trump officials reporting to people off the record, maybe I'd post more about this, that they all expect pardons at the end of the administration because I assume this reflects the fact that they know that they've pushed some envelopes. And that's less a pardon power than a protection racket with some institutional infrastructure. Old pardon corruption took place in the shadows. You're talking about 11th hour clemency and a lame duck session. These pardons are different. They are loud and they are theatrical and they are communicative. So why is this a problem? Well, like I said, its defining feature is its communicative function. These aren't quiet favors dispensed through the Justice Department's bureaucratic channels. These are public drama. And when a president loudly and visibly pardons allies, the message isn't just for the recipient of the clemency. It's for every other ally who might be contemplating regimist transgression. The pardon powers lower the cost of offending. I'm no economist, but I know that when the cost of conduct drops, you get more of it. The inducement operates on two different population segments, and I want to be precise about both effects. The first is civilians. January 6th, of course, is the paradigm case. Trump used the clemency there retroactively and theatrically to broadcast a return on loyalism. He pardoned nearly 1,500 people, commuted the sentences of the leaders of the Oath Keepers and the Proud Boys. He called them patriots subject to political persecution. And these pardons send a message to supporters everywhere: ignore the law, support the patron, and expect payback on the back end. The second population is federal officers, and in some ways, I find this to be the more alarming story. Patronage pardoning induces federal officers to commit crimes that can be unique to federal office holding. Think about Doge operatives unlawfully accessing computer systems. Think about DNI Gabbard and CIA Director Ratcliffe giving Congress false-sounding testimony about discussing top secret military operations on a signal channel with Jeffrey Goldberg from The Atlantic. And think about the rampant non-compliance with court orders, some instances of which risk criminal contempt. These officials all need pardons to be safe from the threat of future prosecution, and they have every reason to believe that those pardons are forthcoming. This is all, of course, indicative or reflective of a broader paradigm of Trumpist law enforcement: reward friends and punish enemies very visibly. This is a five-alarm fire, and I think there's three things that act as accelerants. Number one is like the levels of modern political polarization make it impossible for impeachment and infamy to do the type of checking that the framers contemplated. The second is the Supreme Court's presidential immunity decision, which seems, at least atmospherically, if not hyper-technically, to say that the president's exercise of the pardon power is simply beyond criminal inquiry altogether. And the third is something that I call the leverage spiral, which is every loyalist crime is a unit of leverage for the presidential patron. The more somebody's offended, the more they depend on the patron's grace, and the more that they depend on the patron's grace, the more they can be induced to offend further. All right, what can we do about it? What are the potential correctives? I'll be upfront with you, there's no silver bullets. The constitutional force field around the pardon power is pretty real. What's on the menu are instead sub-constitutional pressure points. These are ways to impose costs on loyalist offending that a presidential pardon simply cannot reach. The first strategy is state criminal prosecution, and it's probably the most important piece of the responsive puzzle. The legal foundation is the dual sovereignty doctrine. The same conduct can offend the criminal law of multiple sovereigns simultaneously. And a federal pardon, of course, does nothing to extinguish state criminal liability. But the practical obstacle isn't so much law as it is professional culture. State prosecutors are in the habit of deferring to the feds, of waiting for the feds. But that makes less sense when the federal government is, at least to some degree, the engine behind the impunity. Now, there are some doctrinal wrinkles to address here. Most notably, some states have single sovereignty rules. And when federal officers eventually assert supremacy clause immunity, state courts got to hold the line. But the core point remains: a credible threat of state prosecution is the most powerful check on the inducing effect of patronage pardons. I'll mention two others briefly because I don't want to cannibalize other people's times. The second strategy is civil contempt. And the usefulness of that tool follows directly from Ex parte Roisman, which says the president can pardon criminal contempt, but not civil contempt. Now, that distinction sat in doctrinal obscurity for a long time, but it sure matters a lot right now. Civil contempt is one of the few tools that bite where pardons can't reach. Third strategy is civil liability, and this requires the most creativity. We've already heard people mention Converse 1983 actions. But we also need to think critically about what the OAG can do in the District of Columbia, because unlike any other jurisdiction in the United States, in the District of Columbia, the president can pardon local crimes. I'll just conclude by saying, with an acknowledgement. I've never written a paper that feels as politically valent as this one does. To be clear, I don't view this as a problem for Republicans or for Democrats, but I do think this acceleration is unique to Trumpist governance. I was unable to stretch my preferred idiom of scholarly neutrality to hide that underlying reality here. I apologize for that, but I did my best.
Well, first of all, thanks to Will and the Institute for having me. It's really great to be here. So my paper, is about Congress's power of the purse, and what it tries to do is provide a historical overview of executive branch spending misbehavior and offer some thoughts about what to make of it. So obviously this topic's been in the news a lot. There's a lot of spending misbehavior going on. But I think what may be less well appreciated is that there was a lot of misbehavior early in the country's history as well. But it went away, or at least it changed a lot in how it shows up. It got replaced with a pretty strong norm of appropriations compliance. So the goal of the paper is to try and figure out how that happened and whether it holds any lessons for contemporary challenges. So there are a lot of challenges to coming to grips with the topic, but I've ended up making 3 central points. The first is that I think contrary to what's sometimes claimed, 19th century unilateral spending should not be a valid precedent for contemporary behavior. It doesn't reflect some sort of liquidation or establishment of executive prerogative. Instead reflects a really different practical, legal, and institutional context. So I'll explain more about that, but I think that's probably the most important point. The second is that I think the strong norm of appropriations compliance getting established is really wrapped up in the formation of the modern administrative and national security state. In particular, the executive branch grew more powerful and unitary at the same time that spending and compliance improved. And I think that historical linkage is important because it suggests we should be wary of decoupling those things in the way some folks now are trying to do. Now the third point is, if this is all unraveling now, what can we do about it? I think there's also not a silver bullet here for reasons I'll talk about, but I make a sort of ambivalent and tentative suggestion that we might want to revitalize individual officer suits as a mechanism of accountability. So anyway, that's the basic point. So let me walk briefly through each of those things in a little more detail. So when I talk about historic appropriations misbehavior, what do I mean? If you look at the early republic and really throughout the 19th century, there were constant complaints about executive officials exceeding appropriations, transferring funds unlawfully, otherwise disregarding provisions in appropriation statutes. So in terms of examples, I mean, George Washington raised this giant militia force to suppress the Whiskey Rebellion, this tax revolt in Western Pennsylvania. He had no appropriation for it. He just moved money from regular military accounts. Some people complained pretty vociferously about this, but he just sort of did it and then went to Congress afterwards and they ratified it. And you see a lot of behavior like this continuing throughout this period. The Army and Navy seem to have just ignored subdivisions of their appropriations, treated them as lump sum. Different agencies kind of move balances forward and backward. And in particular, at certain points, this practice called the coercive deficiency is really routine. Executive officials will just spend or obligate, meaning commit to spend money without an appropriation and then go to Congress afterwards and say, hey, can you give us some more money? And so they create a deficiency, but Congress perceives it as coercive because they feel they don't really have a choice. The agency is going to have to stop functioning or somebody's going to get stiffed. So it gives a lot of kind of unilateral power to the executive. And again, people complain about this. There's this great quote from 1806, this irascible Virginia congressman named John Randolph. He said, "Those who disperse the money in the executive branch are like a saucy boy who knows his grandfather will gratify him and overruns the sum allowed him at pleasure." So like law students run up a bar tab or something. So anyway, he complains about that, but a century later, you see similar complaints, similar pattern of deficiency spending going on. So what should we make of all this? I think, again, sometimes these examples get invoked as reflecting a kind of enduring inevitability of executive behavior or some sort of executive prerogative. I think that's the wrong way to think about it. I think there's a pretty different context at work. And one thing is just practical. There are just huge practical problems with strict appropriations compliance in this period. Accounting and budgeting standards are pretty rudimentary. There are big problems with communication and transportation. Money works very differently. And so there are a lot of reasons why it's just practically inevitable that people are going to have to kind of do things, try and anticipate what Congress would want, not have front-end guidance about it. So it's that practical reality. But I think partly for the same reasons, there's also a pretty different structure of legal accountability in place. As folks here know, government officials all the time are exceeding their legal authority, getting sued, being held liable, and then going to Congress for indemnification. So Congress has this important back-end role in sort of ratifying things that are done, but there's a kind of model of seeking forgiveness rather than permission. And so it's not surprising to see that showing up in spending behavior as well. So I think we have a pretty different structure of accountability now. We expect people to operate inside the bounds of the law as dictated in advance. But then officials often claim some necessity, but they'd have to take their chances on whether Congress is going to ratify it after the fact. So that should impose some restraint. So anyway, I think there's a lot of differences in the context that should limit the continuing force of those examples as precedents. So that's the first point. So the second thing is then, to the extent this did change, and I think it did, how did that happen? And it's hard to pin this down because it's in some ways a gradual process. But I do think it comes to, at least by like mid-20th century, executive officials are taking appropriations compliance much more seriously than they were in these earlier examples. And one thing that happens is there are a series of statutes that get enacted. In particular, this Anti-Deficiency Act targets the practice, of course, of deficiencies, makes it illegal, and then in 1870, and then after 1905, makes it criminal. But I think that's not really the answer or the key thing, because the timing is off. As I just said, that there are criminal penalties as of 1905, but as of 1921, deficiency appropriations are still something like 10% of the budget every year. So I think the more significant changes are institutional. In 1921, Congress undertook this major budget reform that established the Budget Bureau, which eventually became OMB. Also required the president to submit an overall budget to Congress each year, and then established the Comptroller General and the General Accounting Office. So kind of created an infrastructure to, on both the executive branch and the legislative branch, to maintain compliance, and that sort of took hold and grew over time. This is part of this is sort of general mania for budgeting in this period. People saw it as a way of getting government under control. It starts at the local and state levels and kind of gets to the federal level fairly late. There's an article from 1917 that said, "Accounting is the handmaiden of democracy," and said, "Last night the sun of the lawyer set, today the sun of the accountant rises." So fortunately for us, I think the lawyer's sun is still up in the sky, at least I think so. But it does seem to be that this had a kind of enduring shift. But I think that the legal takeaway here is that if this timing is right, then it suggests that this kind of norm of appropriations compliance is getting entrenched at the same time that Congress is building up a much more powerful executive branch under stronger presidential control. And that structure, as people complain, it sort of inverts the separation of powers design, gives the president, the executive branch, a lot of initiative and policy, also in military affairs. But then Congress has this really robust back-end check through its power of the purse, through control over annual appropriations. And so if that's sort of baked into the formation of this structure, I think we should view those as linked kind of conceptually and historically, and resist efforts to decouple them. Okay, so that's the second point. So the last point is then, I could talk about the details. I think they're familiar. I think we are seeing this structure under a lot of pressure right now. I think this administration in particular, as a matter of philosophical commitment, wants stronger executive control over spending, and in some ways is reviving the sort of 19th century tactics of just doing things and seeing if you get stopped, seeing if you get held liable, sometimes asking Congress to ratify things after the fact. It's done that in some way. Sometimes it doesn't seem to even care. So, but if we're kind of entering a possible kind of worst of both worlds, where we have the sort of powerful executive state of the 20th century, but a level of executive presumption from the 19th century, is there anything we can do about it? I think, unfortunately, if my historical story is right, there's again no silver bullet, because the problems are really matters of kind of legal culture, Congress's institutional self-assertion, and other things that aren't easy to fix. But it could be worth giving more attention to the central accountability mechanism that worked in the 19th century, which is the individual officer suit. The ADA carries penal provisions, as Lee explains. Maybe the criminal aspect is less important than the civil and administrative penalties, but there are mechanisms for holding people to account individually for spending misbehavior. I make this suggestion with some hesitation because I think we are at risk of a kind of adverse selection problem in government, that these jobs become very unattractive if you're then going to be personally liable for things your higher ups tell you to do. But nonetheless, that could be an important legal restraint if we are entering a new world in terms of spending. So anyway, thanks again. I'm really looking forward to the discussion.
I'm going to stand too so that Lee can't see that I wrote all the jokes in here and they're not ad-libbed. Including that one, which is pretty prescient. Okay, so so today I'm presenting a paper called The Exclusive Powers Presidency, and the basic idea behind the paper is I want to explore and describe what I think is a fundamental change in separation of powers law, at least in modern separation of powers law. And that's really the court's focus on and really exalting of the president's so-called exclusive powers. And so the paper does a few things. It tries to trace the rise of exclusivity in the Roberts Court, explain what it means when the Roberts Court calls a power exclusive, and then explains what it would mean to take this conception to its logical conclusion. I argue that the Trump administration, many of its most or unprecedented exercise of executive power can actually be understood as plausible interpretations of this exclusive powers conception. And then I explain what I think is wrong with it and what we can do from here. So regarding the rise of exclusive powers, of course, the Roberts Court did not invent the term exclusive powers. What I argue in the paper is that prior to the Roberts Court, at least in modern times, exclusive powers were really seen as a last resort. And you see this most famously in Justice Jackson's Youngstown concurrence, where it's in category 3, and it's obvious that he's trying to do everything he can to disincentivize finding that a power is exclusive. Under the recent Roberts Court jurisprudence, however, really the first step is to ask, does the president have exclusive power here? And we see this, I think, in 3 main cases, Zivotofsky versus Kerry, Shalev versus CFPB, which I'm sure we'll talk about this afternoon, and also Trump versus United States. So in Zivotofsky, the issue there was that Congress had passed a statute that said if you're an American citizen, you could have your place of birth, is this better? Designated as Jerusalem, Israel. Then this was in contradiction to the president's then longstanding policy to not recognize Jerusalem as part of any state. So the court resolved that case by finding first that the president has so-called exclusive power to recognize foreign states, and because the statute interfered with that exercise of power, it was deemed unconstitutional. SALA law is about whether the CFPB could be independent, so could Congress impose for-cause limitations on the president's ability to remove the director of the Consumer Finance Protection Bureau. Again, the court found essentially that the president has exclusive power to remove principal officers, and Congress therefore was interfering with that exercise of power, and that rendered the statute unconstitutional. Finally, in Trump versus US, the issue, of course, was whether President Trump could be criminally prosecuted for his actions leading up to January 6th. And the court found, among other things in the case, that the president had exclusive power to engage in law enforcement investigations, and therefore Congress's criminal statute of obstruction of justice could not criminalize that behavior. So what all these cases show is a pretty consistent method, I think, when there are conflicts between Congress and the president and they get up to the court, and that is the court first asks, does the president have exclusive power? And if the president is determined to have exclusive power, any interference with that power is deemed unconstitutional. So while I think the court has adopted this this primacy of exclusivity, I don't think it really has understood what the consequences would be of this conception, and I actually don't think it knows what it even means to call a power exclusive. And I don't mean that to be super critical, because there's actually almost no scholarship that I could find that interrogates what does it mean when we call a power exclusive. And it turns out that there's more than one way to understand that. And I argue that the Roberts Court has adopted basically, there are 2 principles that are entailed in its conception. The first I call the sole ownership principle, which is the idea that if a president has exclusive power, he's the only actor that has any authority that falls under that grant of power. And the second I call the non-interference principle, and this is the idea that if the president has an exclusive power, no other branch can interfere with an exercise of such power, even if it's exercising its own constitutional power. So on the sole ownership point, this is where I think it's kind of interesting to think about what does it mean to call a power exclusive. So the standard, I would say formalist, and maybe everyone's assumption is that when we call the separation of powers, the allocation of powers between the Congress, the president, and the judiciary exclusive, what we mean is that the reason the framers set up the Constitution in that way was to separate powers. And so that's why the legislative power is in Article 1, and executive power is in Article 2, and judicial power is in Article 3. And the conception here is that the reason to separate these powers is so that they don't overlap. And this is what I call the exclusive as any conception. The idea here is if you have an exclusive power, you're the only actor that has any authority that falls under that power. And this makes sense if I give you exclusive authority to govern a bank account or something like that. The whole reason I'm giving you exclusive power is to foreclose anyone else having authority over that bank account. But there's another way to think of exclusivity and why we divide up powers, and that is that we give different powers to different actors to accomplish different tasks. And this is what I call the exclusive as all conception. And the idea here is if I give you an exclusive power, you're the only actor that has everything that falls under that grant of power, but you're not necessarily the only actor that has anything that falls under that grant of power. So I understand this is abstract, so let me give you an everyday example to explain what I mean here. This is too everyday for me. I imagine I have two home repair problems. My HVAC unit is broken and my hot water heater has a leak. And I hire two different people to fix those two problems. So I hire an HVAC repair person and I say, you have exclusive power to fix my HVAC unit. And I hire a plumber and I say, you have exclusive power to fix my hot water heater. And in doing this, they have exclusive as all grants of power. So only the HVAC person has all the authority that's necessary to fix the HVAC unit. They can take the cover off, they can rewire it, they can check the vents and so on. And only the plumber has all the power necessary to fix a hot water heater. They can repipe it, they can take out the pilot light, they can flush it, and so on. But this doesn't mean that they don't also share authority. So both of these appliances run on natural gas. And so in granting both of them power to fix their appliances, I've given them authority to turn the gas on or turn the gas off. And if they cooperate and they both want to turn the gas off, this presents no problem. Or if they both want to turn it on, this presents no problem either. But what happens if they come into conflict in this area of shared authority? Exclusivity in that context just tells us nothing about how to resolve the dispute. So if the HVAC repair person says, I want to turn the gas line off, and the plumber's like, no, I need to turn it on to test this fix, they can't just say, I have exclusive power, and therefore I win, because they both have exclusive powers that encompass the gas line. And it just doesn't make sense to say that because the HVAC repair person has authority over the gas line, then that means the plumber cannot have such authority. That's just not what the grant of different powers to each person means. So I personally think that that's a better description of how the Constitution allocates powers to the branches. But my point here is that that exclusive as all conception is just not useful if you're resolving disputes. And so the Roberts Court, when they're using the term, they must mean the exclusive as any conception, because that's the only conception that actually helps us resolve conflict. Then with respect to the non-interference principle, I explained that none of these cases can actually be resolved solely on these sole ownership lines. And that's because all three of the cases I described, none of them involve an instance where Congress is actually trying to exercise a power that they say was exclusively the president's. So in Zivotofsky, the court goes out of its way to explain that place of birth notifications on passports are not actual formal acts of recognition. The issue there was that Congress was interfering with the president's ability to exercise his power, supposedly exclusive power to recognize foreign states. Same goes with seal of law. Congress is not actually trying to remove the director of the CFPB. The problem is that they were interfering with the president's ability to exercise that power of removal. Trump versus US, the same thing. Congress is not trying to engage in law enforcement investigations. The issue was that it was interfering with the president's ability to do that. And so in this way, I think that when the court calls a power exclusive, it means these two things: sole ownership and non-interference. And so what would it mean to take this conception to its logical conclusion? So I argue that the basic upshot would be, given the powers that the court has called exclusive, most prominently over law execution, that the president would have essentially unconstrained power to, for example, destroy administrative agencies and the civil service entirely, which we'll talk about later this afternoon, ignore administrative law, spend money. Why? Because these are all examples where Congress is interfering with the president's exclusive control of law execution. And if the court were to adopt the notion that the president has an exclusive power to conduct diplomacy, which is a very longstanding executive branch position, then I think that would render most foreign affairs and immigration congressional statutes also unconstitutional because they interfere with the president's ability to conduct diplomacy. Beyond this, by the way, the court has said if the president's power is exclusive, it not only disables Congress, but also courts cannot review such exercises of power, which would mean that the president could also either be non-justiciable, as Payvand is talking about, or he could just ignore those orders because they would interfere with his authority. I'm almost done. And so I then show how the Trump administration can be understood as what I think of as a variant of the exclusive powers presidency. Many people are very critical of the Trump administration's expansive executive power claims, but I think that they are plausible interpretations of the court's own doctrine. So this all seems to me not great. And so I then try to transition to explaining what I see as really the problems in the doctrine. And I think at its core, it's not compatible with some fundamental separation of powers precepts, but it's also not compatible with various other strands of the court's own doctrine. And I think the incompatibility stems from two problems. One is in application and the other is in principle. So I think with respect to the sole ownership principle, there are some powers that only the president possesses in the exclusive as any sense. The pardon power might be one of them, perhaps. But in its cases, the court has been way too quick to conflate powers that I think are internal or inherent to the president with powers that are exclusive or solely owned by the president. The second problem is with the non-interference principle, and I think that this principle just does not work, at least as applied as a rule. The whole idea behind the separation of powers, as Kurt kind of started us off, ambition was meant to counteract ambition. How were the branches supposed to counteract each other's ambition? They were supposed to interfere with each other's exercises of power using their own powers. And so I think it just cannot work to have a rule that says if one branch has the power, no other branch can interfere with an exercise of that power, because they were meant to. So after putting all this out, I then conclude with some alternative methods that the court could use instead of exclusive powers. I argue that they should use interest balancing, which is something I've argued for in the past. But if it doesn't like balancing, because as Will has said, it fears balancing, it could try to use core periphery distinctions, it could try to use historical gloss. All these methods have their own problems, but I think they're superior to this exclusive powers conception. And I also explain that if it feels very, very drawn to these exclusive powers, I think there's more work they could do to find procedural limits on the president's exercise of such powers that derive from Article 2 itself. So with that, I'd love to hear people's comments and questions, and thanks so much.
Thanks to all of the panelists for describing these papers. They're all, if you haven't had a chance to, definitely go to the box and look at those papers. They're all great, and they all address different topics, but in ways that kind of intersect usefully with each other, I think. And thanks for the shout out about historical gloss. Good mention on that one. So I wanted to first, before we take questions from the audience, I wanted to see, these are all experts on different aspects of separation of powers, to see if you wanted to make any comments on other panelists' presentations or papers, and take that opportunity. So anybody want to do that? Be the first one.
I'll have a question for Payvand. So it occurred to me as you were speaking that the one area where the court seems comfortable adjudicating, am I still too loud? These disputes is in the executive privilege informational dispute domain. And it seems to me that that's like the one area where the court actually has a coherent doctrine of how to resolve those disputes, which is this, as I'm shouting out again, this interest balancing method, essentially. Whereas in the other areas, war powers, whatever the other area is, there's just no coherent way for them, at least historically. Everyone knows separation of powers adjudication has been an incoherent mess for a very long time. And I wonder if part of the reason that they're comfortable resolving the information disputes versus the other ones is that they actually know how. And do you think that does any work in terms of why they are willing to adjudicate those, but not the other ones?
So one thing that I think about all of this is when something appears like when there's a dispute that appears like something courts are familiar with, they're more inclined to reach for it, especially in the lower courts, right? They think, I can do this sort of thing without disrupting other mechanisms. So courts can handle information disputes, and they handle subpoena disputes with private parties in Congress. They can do that. They issue their own subpoenas, right, that they know how to enforce. But I don't know that it's tethered necessarily to the fact that they have the scheme of interest balancing for executive privilege versus congressional right to information, because they haven't actually resolved that on the merits, like at least at the Supreme Court. It hasn't gotten there. Like, what do you do when you get to the merits and we're right at the head of, does the executive's claim of privilege over this document matter? Or is it Congress's need for the information? That's the one that ultimately does it. So we still don't know exactly how that shakes out, but I think the fact that it bears a likeness to things that they've seen in other domains is the reason why they're more likely to approach, approach the merits in these cases. But I think the importance of the appropriations power is something that also makes courts a little bit more likely to take those on. So those are the two domains that I've seen them more ready to go through some of the jurisdictional barriers than the foreign affairs space and things like that. So, but not because they have a rubric, they haven't adopted your view yet on it, or Kurt's view, right? But if they did, great, potentially.
I have just a quick comment for Shalev, actually maybe two. First, I hate this kind of comment that I'm about to give, which is like, oh, but like, what about what the cases say? Because I feel like I should be like hanging from a flagpole by my underwear or something. Like I'm gonna get a wedgie for being the guy. What about the cases say? But like Klein, right? Like we teach that case every year in Fed courts. Like nobody knows what Klein said. I mean, that like the language in Klein is totally inscrutable, right? If we took the language there seriously, it'd lead us to all sorts of places that make no sense. And like I went back and I read Zivotofsky last night, and like actually like Kennedy's pretty careful in terms of saying like, well, the exclusive power here is really just this like thing with recognition, and then there's all these places upstream and downstream of recognition where Congress can totally regulate, and maybe it like messes with the efficacy of recognition, but like recognition, that's really just a presidential power. And I guess if the story you're telling is that, well, you know, there's this yawning gap that's opening between like what the Roberts Court is saying and like what it's trying to do, and that makes the law really unstable. I question whether that instability is really something that's new, because there's always kind of been like this yawning gap between the way the court talks about executive power when it wants to endorse that power and like what it's ultimately doing. And I think that the difference between those two gaps might in fact be much, much, much smaller than you're crediting in the paper.
Thanks. So I think that's a fair critique. I mean, on the Zivotofsky point, I think you're right that he's careful to say that, no, it's just the recognition power and Congress can push back using its war powers. It can use push back by, once the president recognizes they can declare war, they can use tariffs. I think part of my point is that it just doesn't make any sense. Like, why? So Congress and Zivotofsky is exercising its power to regulate passports that the court acknowledges it has. And for some reason, it says that when that power conflicts with the president's power to recognize, the president wins. You could say the opposite, which is, oh, there's a conflict in an area of shared authority. They both have authority over how place of birth designations on passports should look like, and so Congress should win. But what it says is that the president wins, and it wins because when the president's power is exclusive, it disables the Congress from acting upon the subject. Why on earth that still allows Congress to, impose an embargo? I don't know how to put those two things together. And so then you might say, well, that just shows that you shouldn't be so worried because the court is just being incoherent. And so why are you picking one part of the opinion and taking it seriously, but not the other? And I've struggled a lot with that in writing the paper. And part of the reason I approached it the way I did is that the Trump administration and the executive branch is going to take the executive-friendly parts seriously. And for some of the reasons that Payvand articulates, courts aren't going to review almost any of these things. And it's just not, when I was writing it, especially, it's just not clear to me that the court doesn't mean what it says in those cases. And it's said them over and over again. And in Trump versus United States, it's extremely, kind of emphatic that if the president has exclusive powers, it disables Congress, courts can't review, and they say that over and over. And so the bet might be that they're going to have this line of cases and then they're going to contradict it in these other line of cases. And, that might be what happens, but I'm not sure it's what's going to happen. And so part of the hope of the paper was to show what would it mean to actually take this idea of exclusive powers seriously without all the contradictions. And I think that's a pretty bad picture. And so my hope is to dissuade them from adopting that in the future. So I hope that's responsive.
I had sort of a theme that occurred to me in the papers, probably most directly with Payvand, but I thought I'd throw it out there, which is, it seems to me the central problem in the separation of powers system right now is Congress's institutional weakness. And it seems to me that is partly a function of the partisan polarization, but probably also has to do with the media environment. It seems to be showing up in all different systems. But the way I thought about it here was the executive branch does things. It can just, take action. That's its defining quality. But then the question is whether that gets perceived as legitimate. And a big function of both courts and Congress has been to perform that legitimating function. And courts seem to have pretty robust legitimacy, and they can approve things. But the question, to preserve their legitimacy, they have to show some independence. So I think in the cases Shalev is talking about, they hint at these broad views, but are a bit hedged, and we'll have to see how things play out over time. But I guess the point with Congress is, it seems like Congress historically is sort of thought of as the main source of legitimacy in the system. It's where you go and bargain over things. In terms of my topic, you pay off people who are going to be unhappy with some new settlement. And if that's not working, Payvand is sort of picking up, maybe what explains the trend she's picking up on is you see Congress itself increasingly going to the courts to preserve that legitimacy function. And then in terms of Lee's topic, I think the one check you point out on pardons is they have to be retrospective. It's only Congress that could prospectively change the law. But I think in earlier eras, Congress would have played a big role in sort of highlighting illegitimate pardons, exercising political, pushback. So I don't know, it's a bit jumbled, but it just seems like we're getting this dance between the executive branch and courts, and maybe the big problem is that Congress isn't playing the role of kind of sorting out what's legitimate and not, that it maybe historically did.
Any responses or follow-ups on any of that? Okay, I'll just throw out one question of my own, and then I do want to take audience questions. So, Shalev, on this idea of exclusive powers, one of the hot topics right now is when Congress says "thou shalt" or "thou shalt not" do the following to the president, which isn't quite the indirect scenario as you have in mind. So, very topical example: Congress has passed a law that says president may not withdraw from the NATO treaty unless the president gets Congress's approval. It's a law that was signed by Biden a couple of years ago. You can imagine laws like thou shalt not use any money to talk to Iran for any negotiations or something. And the executive has been worried about those, not just in this administration. How does your paper help with those kinds of things? Maybe it's just a different issue. Those shouldn't be exclusive anyway, under any conception of exclusivity for whatever reasons. Or is there something in the framework that also kind of addresses these more direct conflict things?
I think that I can tell you how I think they would think about it and how I think about it. So I think there is a distinction between Congress trying to exercise a power that they think, that the court thinks or the president thinks is his own, and also, and I think in the same bucket is Congress completely prohibiting the president from exercising a power. And then in the middle bucket, which is the one I think most issues actually arise in, not all, but most, is Congress interfering with, but rather than negating or doing it on its own. And so you could say that the cases you're bringing up, the court might feel more comfortable saying that those are unconstitutional because they're a negation of the president's authority. I still, in those examples, I have a hard time with that, because what that is doing is it's really, again, I think it's just prioritizing the president's power over Congress in a situation where they both seem to me to have power. So why can Congress tell the president not to pull out of NATO? Well, because it had the authority to put Congress in NATO in the first place. And I don't see why its Article 1 authority and the Necessary and Proper Clause don't give it also authority to regulate withdrawal from a treaty. What was the other example you gave?
Negotiating with the country.
Yeah, and then negotiation, Congress has plenty of foreign affairs power, regulating foreign commerce, et cetera, that gives it authority to dictate foreign policy. And so it seems to me that in all these disputes, like the president has, and Congress actually has textual support for its foreign affairs powers, unlike the president, but which you might weight more or less. But I think in all these disputes, the president has a claim to having constitutional authority, and Congress has a claim to having constitutional authority. And so we're an area of overlapping power. And the question is, who do you prioritize in such areas of overlapping power? And I think that is the question of separation of powers of our time. And we don't have a great answer to it, except for interest balancing, which is the best answer to it. But more seriously, I think it's just a genuinely hard question. But the line drawing of just prioritizing the president over Congress, to me, seems to me indefensible.
Thank you. All right, I see hands going up. Yes, Bridget.
I think in a lot of the papers and the issues that you're addressing, the central structural problem is less one of the battle of the branches and more of the reshaping of the kind of internal organization of the branches. So Payvand, you have this elegant point about how judicial standing doctrine can change the incentives for congressional organization by putting a thumb on the scale in favor of these institutional interests. And Lee, in your paper, you call attention to the effect of the pardon power as a kind of supervisory tool over people within the executive branch. And of course, when we talk about appropriations, the kind of rising of the GAO and of OMB are what are shaping kind of how the appropriations power gets used. So 2 questions related to this. One, is this the kind of site of structural constitutional law in the federal government, sort of what goes on internal to each branch, as much as, or more important, or whatever, as what goes on between those branches? And what intuitions should I have about this? So in the federalism world, Payvand and I wrote a paper that said, hey, the Supreme Court should be very careful about using doctrines that just incidentally have the effect of encouraging states to reorganize their governments in particular ways. They should be very deliberate about making that choice, because that's such a core part of institutional autonomy, how you choose to arrange your government. Should I have the same intuition about the court doing something that incidentally sort of changes how Congress is organized? Or should we see that as a productive kind of a productive way of noticing interaction between the branches?
So I'll start by saying, having co-authored your paper and written my own this time, I think that we should care about the court incidentally affecting how another branch is shaped, insofar as it seems not to care at all about that now. So I'm not saying that the idea that Congress is incentivized to reshape itself based on what the court has said is itself enough of a reason to change the justiciability roles or how they articulate them. But I don't think that that is a consequence that courts think about. And especially in the context of a separation of powers case, where we know in all instances where Congress is suing the president, the benefit of the status quo is the president's. That's why he's not bringing the case to begin with, right? The status quo is benefiting the president, the executive branch. So I think in that instance, you want the court to at least consider how I say no or what I say now is going to have consequences for the internal structure of the other branches, without saying how the other 2 branches fight should inform how the judiciary structures itself through justiciability doctrine. Because you could just hold that it goes the other way. Before Congress ever sued the president, courts never had to contemplate whether Congress could sue the president in a federal court. But now I think it does have to do that, and it should. And so I think it goes both ways with the internal organization and structuring, and that it should go both ways, but it is not necessarily determinative of what rules should be articulated.
I think there's no question that this is most salient with respect to the executive branch. So I'm going to, if it's a friendly amendment, to treat it as a question about the internal structuring of the executive branch. And what's interesting to me is I think the broader public knows it more as like the bad man problem, but the court seems very much at cross purposes, right? It's trying to write rules that order a modern presidency that don't necessarily work well with the modern president. And there's a lot of tension between those 2 things. And I think the court sometimes is trying to do the right thing, like in the presidential immunity case, but it feels right now like very, 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 very wrong in view of the way this particular president has structured the administration, and remains to be seen whether or not the fruits of that project have positive returns when we get to see how it works in future administrations. But I just think that the court is intuitions about the way governance works inside the executive branch that were forged largely in the 1980s at the Reagan Justice Department aren't necessarily producing terrific intuitions about the way it's going to work now.
So I guess 2 thoughts. I mean, one is just as a formal matter. I mean, I think there's a certain asymmetry. I think Congress gets to structure the executive branch. There may be exclusive power of oversight to some degree, but I think it's important that Congress designs the agencies and determines the resources of the executive branch. So I don't think there's a problem with Congress doing that. But in terms of my topic, it is interesting that Congress created the Budget Bureau, as I was explaining before, as well as the GAO, and for a long time they'd have disputes over certain things, but worked in tandem in a lot of ways to maintain kind of strong compliance within the executive branch, and now that's broken down, and part of it is a kind of deliberate effort to change what OMB does, make it more an arm of the president than a kind of neutral technocratic body. But again, I think it has a lot to do with Congress's institutional weakness. Like I looked at some somewhat parallel debates in the Reagan era or the Nixon era, and Congress is just a very different body. It's not working on completely partisan lines. Reagan had this very effective OMB head named David Stockman, and he wrote this. He was trying to slash the budget, did various aggressive things, but just kept getting pushback against Congress. In his memoir, he equates his interaction with the Senate Majority Leader as feeling like getting beaten with a leather strap by his father, which sort of captures this sense of like dependence that I just feel like somehow is not there anymore. That I don't think people in the executive branch view Congress as having that level of authority, and if that's the problem, then it's a really hard problem to fix.
Great, Rick.
I wanted to ask both of you guys, what's responsible for the court getting so involved in interbranch disputes? Because for the first 187 years, basically from 1789, I'm going to say till 1976 in Buckley, the court was minimally involved. Think of it, Tenure of Office Act, Jackson firing Duane. They were all political showdowns that were resolved politically. And maybe from 76 into 2010, you had a few opinions, Chadha, Buckley, Boucher, but they kind of back off in Morrison. But since 2010, the court's been on steroids. Do you have a political science theory for why the court feels that it should lay down the law? I mean, I can think of the Mo Howell theory on presidential creep. It's just the president's powerful, and he's always going to be powerful. Or I could think of the Whittington theory. The political branches actually want the courts to do this because Mike Johnson doesn't want to have to be put on the spot, exercising individual autonomy in defense of your positions. But I don't know what the theory is, but this is wild that the court's calling the shots. That we're trying to parse these opinions to figure out stuff that in the day would be handled completely politically.
Okay, well, it doesn't correspond directly to 2010, but I do think the federal government has expanded a lot. It's doing a lot more stuff and creeping into other domains. So there's more stuff for people to challenge and bring to court. We had an era of very relaxed justiciability rules that's then was tightened over time. So people decided to start resorting to adjudication for things, right? So even when we talk about the structural injunctions having to do with private, semi-public instances, we started seeing courts' role in society as being something different. And so I think when you see courts' role in society as different from just private dispute resolution and not sort of responding to a political situation, then you can move the ball a little bit more and start bringing more separation of powers type arguments into the court also, because you have a new role for what you think courts are. And then the other part that I would talk about is the justices now are all trained in law, and they're lawyers and former judges, and that wasn't always the case beforehand. And so part of it might have to do with legal education and where they served as lawyers. Most of them have served within the executive branch, right? And so they see some of the frustrations of what it's like if we don't get good law on the executive branch's side. But I think they were raised and acculturated in a different sort of landscape that then made them think, I know something about separation of powers and I can say something about it. And the role of a court is to do just that, because we've seen courts structuring and participating in sort of social problems. And this is another version of a social problem. So is that a political science theory? I don't know, but that's a Payvand theory.
I had a thought. I think it has a lot to do with the level of partisanship. I mean, partisanship incentivizes hardball. you get interbranch conflicts, and then there's no one knows how to resolve them. You know, Supreme Court has huge power and legitimacy coming out of mid 20th century. So people turn to the courts. Well, they'll settle these things, but then it just sort of snowballs because not only do they end up getting cases where they need to settle questions, but then people want to capture the institution and use it to create rules that are more favorable to them. So I think it's a function of the kind of hardball between the two political branches and the way the court has this legitimacy in being able to settle things.
I wouldn't want to entirely separate what I'm about to say from the point about constitutional hardball, but I would just add that it's at the same time that the political conditions for that to happen have become more favorable to that sort of practice. So too have the media conditions change in ways that reward hyperpartisan behavior, and not only partisan polarization but effective polarization. And with that media environment, with those political incentives, it just seems like an inevitability.
Great. I know there are many more hands, but my only job, literally my only job on this panel, is to keep the time. So I want to. This was a great discussion. People can ask questions afterwards. Thank you very much for the papers and discussion.